Okay, well, I believe that I'm live. So hopefully if I press the correct buttons, then you can see me now and we can have a nice chat about a very important thing. So if this is the first time you're joining us, or frankly, if it's the 20th time you've joined us, welcome. My name is Lior Samfiru. I'm an employment lawyer. In fact, they call me the employment lawyer. Not very creative, but that's what I do. I help solve workplace problems. I help solve workplace issues. I'm the guy you speak to if you have a problem, if there's anything to do with your job, your workplace, your compensation, whatever that issue is, now's the time. And I'm here taking your questions. So again, my name is Lior Samfiru, and I'm here today for one purpose and one purpose only, which is to answer your questions. If you have a question about your job, if you lost your job and you want to know what you're owed, if you're worried about losing your job and you're wondering, hey, can my employer let me go? Ask. If you're facing some changes to your job, maybe your employer says, effective next week, we're going to take you, have you take a different role. Can they do that? What should you do? How do you respond? Ask the question. Maybe the business you're working for has sold and you want to know, do you have to continue working with the buyer? Do you even get a job with the buyer? What to do? Ask. You have a question, ask it on Facebook, on YouTube, whatever that is. Now's the time to ask your questions, whatever that issue is. Now, I'm going to give you some other contact information. You may hear something here that triggers another issue, or you want to have a private discussion. You don't want to ask the question on Facebook or YouTube. Not a problem. You can reach out to me directly so we can have a private chat by phone, by email, whatever you want. So that website to go to is employmentlawyer.ca. Again, employmentlawyer.ca. That's my firm's website. You'll see a lot of information about employment law, but you'll also see my contact information, the contact information from my team, email addresses, phone numbers, fax numbers, everything is there. So if you do want to have a private chat, if you don't want to chat on Facebook, you don't want to chat on YouTube, not a problem, go to employmentlawyer.ca. But this live session here is for you. We want to answer questions. I want to answer questions. And because we have people watching this, when you ask your question, you'll help others. Because I guarantee you that the issue that you may be facing is not unique to you. There maybe other people facing the exact same issue with the same questions, with the same problems. So you'll be helping them as well when you ask your question. Now, in between your questions, as I'm waiting for them, and I will be answering them as they come, I want to talk about some other things. I want to answer some common questions that I get every day. So I'll be going through those in just a few moments. But we're going to start with some questions right now. First question of the day, and welcome, comes from Nita. It says, my company gave me a termination letter on February the 23rd, saying my employment will end April 15th. On March 19th, they told me my employment is not ending. I don't want to stay. My question is, will I still qualify for EI? So this is obviously not a comfortable situation. If in fact your employer, before your last day, said, well, we're not going to end your employment, then in that situation, if you decide not to continue working, that's a resignation. And because it's a resignation, you're not going to qualify for EI, and you're also not going to qualify for severance. So if in fact your employer does that before your last day, now if you were left, and then the company says, no, come back, that's a very different situation. You do qualify for EI. But if that happens before you're actually terminated, no, you wouldn't qualify for EI in that situation unless there's a really good reason why you can't continue working. Maybe now it's become embarrassing. Maybe there's changes to the job. But unless there's a really good reason, if you don't stay, sure, you don't have to, but you wouldn't get EI or severance. Nita, if you want to chat more privately with me about this, please contact me. Happy to have that private discussion. Employmentlawyer.ca to connect with me privately. Thank you very much for that question. Next question from Laura on Facebook. Welcome, Laura. I have long-haul COVID symptoms, and I've been off work on a sick leave since December. I think they have sent me a registered letter to end my employment. Can they fire me? So they certainly cannot let you go because you have COVID-19. And again, depending on the province, if you're in Ontario, for example, if in fact your symptoms are COVID-19 related, you're allowed to be on leave until July, and they cannot let you go at all. So number one is we want to find out why they let you go. If the reason has anything at all to do with your absence, no, that's illegal. That could also be a human rights violation. Not to mention you're also owed severance. So that's not legal, Laura, and I want you to connect with me as soon as possible off Facebook so we can look at that letter. Let's review that letter together. I'll tell you exactly what to do, and I'll get involved on your behalf if I need to, either to preserve your job or to get you the compensation that you're owed. But no, it's not legal. That's a very, very important question, especially these days. So thank you very much for that. Laura, so connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. Thanks. Next question from Paul on Facebook. My current employment lawyer is taking too long to resolve the issues with my former employer who terminated me without cause over 2 years ago. My former employer is now threatening to seize my group benefits. Why are they not willing to negotiate a full and final settlement? How can I move my file with my current employment lawyer to you and your firm? So obviously I don't know anything about your matter, so I can't say why they're not willing to negotiate, but it's inconceivable that it would take 2 years. Frankly, it's inconceivable for it to take 1 year. A lawyer that knows what he or she is doing will resolve this quickly. If you're owed more, you're going to get more, and it's silly, ridiculous, and unacceptable to have to wait that long. So Paul, here's what you do. You contact me off Facebook. Let me look at your matter. Let me assess what you're owed, and then we'll talk about how to transfer the file. It's nothing. It's an email from you to the other firm. But let me review the matter first so I can give you a proper opinion about what you're owed, about what needs to happen, and how do we make it happen. Okay, so Paul, don't sit on this. It's ridiculous. 2 years. You may as well be saying 20 years. It's ridiculous completely. I want you to connect with me right away, employmentlawyer.ca, Paul. Let me review it. Let me give you a good analysis. So Laura, in BC, you say, even in BC, you cannot be let go if you have a medical condition that's a human rights violation. So we need to sit down and have a chat, okay? We have offices, by the way, Ontario, BC, Alberta. So we got you covered anywhere in those provinces. So Paul, Laura, you guys need to reach out to me, okay? I wouldn't wait. Time is not on your side here. Employmentlawyer.ca, phone number is there. Email address is there. It's all there. So check it out, please. Next question from Nandani. Again, if I mispronounce, I apologize, Nandani. Nandani says, I'm on long-term disability due to a car accident. Could my employer give someone else my job? So here's how that works, Nandani. The only thing you should be worried about right now is getting better, right? Your employer is allowed to run its business, which means while you're away, if you're going to be away for a long time, they can hire someone to do the job because they need the job done. That doesn't mean that they've let you go. That means when you're ready to come back to work, they have to make all efforts to take you back to the same job at the same position. They have to make that effort. If they don't make that effort, that's a human rights violation. If they don't try, if they say too bad, we don't even care, that's illegal. Let me know on that point. But we only look at that at the time you're ready to come back to work. For now, I wouldn't worry about it. For now, do what you need to do, get better, follow your doctor's advice, get whatever treatments you need to get in order to get healthy. Once you're cleared to come back to work, get a doctor's note from your doctor to the company saying, Nandani is ready to come back to work. Once you do that, if they do anything other than take you back, I want you to call me, all right? Don't worry about it right now. You may be off for a while. Get better, get healthy. If there's a problem at that time, contact me, all right? Employmentlawyer.ca. And again, we're getting questions. Happy, I love it. Please ask your question. You have time. There's no rush. Ask your question right now, just like everyone else is. Next question from Joe. Joe says, I have two questions. Number one, do I have rights to my employee file? And number two, does the employer have the right to keep issues I had decades ago in the employee file? So unfortunately, Joe, you do not have a right to the employee file. Even though it's the file about you, it's the company's property, and they can put in it whatever they want. It doesn't mean that they can do anything with it. It doesn't help them in any way. But if they want to have a file and have everything in it, even from 10 years ago, they can do that. But again, that's not going to help them. It's not like if they have something from 10 years ago, they can use it against you. But if they want to have it in the file, they can. And you can't require them to give you a copy, and you can require them to delete it or to change it. All right. So unfortunately, not much you can do there, but I wouldn't worry about it. It means nothing, right? They can't do anything with it. So don't stress out over it at all. Thank you, Joe. Great question. And please ask away as well. From Jan. Jan says, I'm replying to Paul. So, okay, so she says that she transferred the files to us and she has a hearing scheduled at the end of the month. So yeah, I'm glad, Jan, and Paul, yes, you as well, contact us so we can take a look at what's happening here. You should not be waiting 2 years, nonsense. If a lawyer knows what he or she is doing, we can get this resolved. Thank you very much for that. Next question, please ask away. We got time. It's only 10 after 1 here, or 10 after 10 in the morning if you're out on the West Coast. Plenty of time. So from Lyle on Facebook, welcome, Lyle. It says, after being placed on a medical leave, as my employer claims they can't accommodate my restrictions of working the day shift only. They have no intention of accommodating anytime soon. My EI runs out at the end of September. How do I propose a buyout? I'm losing so much money every month by my employer keeping me off. First of all, Lyle, you yourself can't propose a buyout. I mean, you can propose it, but they don't have to do anything about it. We need to force the issue. So here's the main thing, Lyle. The question is, can they accommodate you, but are they choosing not to? If they can accommodate you and they don't accommodate you, that's a human rights violation. That's illegal. That's also considered a termination. So not only are you owed human rights damages, you're also owed a severance package, and it can be significant. So the real question is, can they accommodate you but are choosing not to? If they legitimately cannot, it's impossible to accommodate you, then you have to stay off on a medical leave until you're clear to return to work. So let's talk privately. I want to understand what your limitations are, what the company is able to do. So let's be clear on that, okay? Contact me. Don't wait on this. Don't wait till September. That would be crazy, okay? Let's deal with this now. Go to employmentlawyer.ca. So let me see. I'm trying to scroll down here. By the way, Dan, if you're watching, I still can't scroll down. So for next question from Leroy. I'm from BC. I would like to know what is the statute of limitations when it regards to severance pay. I was fired for cause, but didn't get a severance. So it's 2 years. So the statute of limitation is 2 years. You have 2 years from when you were let go to pursue your severance. I wouldn't wait 2 years if you cannot. But if it's been 2 years or less, you can. 2 years and a day, too late, 2 years, okay? Very important. If you've been let go, call me. Don't wait on that. Employmentlawyer.ca for all that information. From Jen. Our employer continues to deny all vacation requests at our work. This is year after year. What is the law on vacation? So Jen, your employer is allowed to decide when you take vacation. So they don't have to give you, unfortunately, vacation when you want to, as long as they schedule it for some time. So what they can't do is say no vacation. But they can say you'll take vacation in June instead of in September. So they can do that. So, Mike, if they won't schedule vacations, it's simply we've eliminated vacations. You can file a complaint, and you must file a complaint with the Ministry of Labor. But if they simply decide when to do vacations, that's not nice, it's not fair, but it's also not illegal. An employer is allowed to decide when you take vacation, okay? As long as they let you take it. So, Jen, hopefully that helps clarify. If you have a follow-up question, please ask it. Happy to chat. And happy to answer more questions. Again, ask your questions as well. I'm here, you're here, let's chat. Next question is from Aaliyah. Aaliyah on Facebook. I'm currently a full-time worker. I have been experiencing a lot of discrimination by my supervisor. I have talked to my GM and the HR of the company, but they only take their side. Oh, man. I just lost that question because I can't scroll down. So here's how it works. You have the right to be harassment-free. You do have that right, okay? So if you're being harassed or mistreated you need to give me a call. I can force the company to deal with it. The company has to investigate. They have to take legal measures. If you can't deal with it internally, then we have to deal with it externally. I can force the issue, or I can potentially get you out of there with compensation. Just being, a victim of workplace harassment is not the solution. Okay, it's not the solution. We can do something about that. You have a right not to be mistreated, and your employer has that obligation. If they don't meet the obligation, let me force that issue. Okay, thank you for that question. Employmentlawyer.ca. From Antoinette, I feel harassed at work and not treated as fairly as others. So Antoinette, as I was saying, speak to HR, speak to the owner, speak to the right person in your workplace, okay, about the situation. Make sure that they know, put it in writing. Okay, once you do that, your employer has to investigate, make sure that that things are happening, and then fix that problem. If nothing happens, if you talk to them and they don't do anything, that's when you deal with me. That's when you contact me and you let me deal with it externally. You want to put it in writing though. Send an email to HR saying, here's what's happening, please help me. Please do something about it. They have the legal, not just the moral obligation, they have the legal obligation to do something about it. So Antoinette, do that. If nothing works, call me, let me deal with it, okay? And for Antoinette and anyone else, employmentlawyer.ca. Lise asks, you say that 2 years is too long to get a settlement. What is a reasonable length of time to reach a settlement? Well, most cases should resolve within a few weeks. Okay, Lise? Most questions should resolve within a few weeks, up to 3 to 4 months. Okay? Anywhere from 2 weeks to 4 months, 98% of cases will resolve in that period of time. And probably 80% of them are going to resolve within a few weeks. Okay, so that's the reasonable period of time. It should not be longer than that. So Antoinette, you say you feel not supported. I get it completely, but you have to give the company a chance to do something about it. You have to. If you don't, if they can say, well, we didn't know about it, you didn't tell us, nothing is going to get done, right? If you're being harassed, people are not treating you properly, tell HR, but in writing. If it's not in writing, it doesn't exist. Putting it in writing protects you, okay? Please do that and call me if there's still a problem. Next question, again from Facebook, from Claudine. After you are let go, can the employer ignore your emails for information and not reply back? Well, there's no legal obligation for someone to email you, right? So if you're let go, your employer's obligation is to pay you what they owe you. That's really the only legal obligation. So Claudine, if you're let go, they owe you a certain amount of compensation. And for Claudine and for everyone else, if you want to know right now, this very moment, how much you're owed, easy. Go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You'll see our severance calculator tool there. It allows you to find out in seconds how much you're owed. 6 months, 12 months, 24 months. How much compensation, how much severance you are owed. So Claudine, I bet you anything that whatever they've offered you is a lot less than what you're actually owed. Go to pocketemploymentlawyer.ca, use our severance calculator tool there, and find out exactly what you're owed. Same with you. If you lost your job, if you're worried about losing your job, maybe your best friend has lost their job. Again, pocketemploymentlawyer.ca. Let's make it a rule. No one signs a severance offer without going to pocketemploymentlawyer.ca. Thank you for that, Claudine. Next question from Facebook. Tammy. Hi, Tammy. I've been employed for 23 years in a long-term care home. I've been off for over 2 years, sick leave due to mental health. My administration called me due to time off. My full-time day job is gone. She will call me with what job there is. That was 2 weeks ago. Can they do that? So first of all, Tammy, I want to know if you're part of a union or not. If you are part of a union, the only one that can advise you whether this is legal or not, the only one that can help you if needed is the union. Only the union and no one but the union. So if you're unionized, you have to talk to the union, and there's really nothing else you can do. If you're not unionized, the question is, are you ready to come back to work? If you're ready to come back to work, no, they can't change your job. If you're not ready to come back to work, the issue is moot at this point. Let's wait to see what happens when you're ready to come back to work and then deal with it. If you're not unionized and you're ready to come back to work, but they have a different job for you, we call that a constructive dismissal. That they don't have a right to do that, and you're going to be owed severance potentially as much as 2 years' pay, especially after all these years you've been there. All right. So if you're not unionized, you want to come back to work now, they don't have your job ready now, call me. If you're unionized, only the union can help you. If you're not unionized, but you're not ready to come back to work, let's wait until you are ready. Anything up until that point, frankly, is academic because you're not going back to work anyway, right? So hopefully that helps, Tammy. Any follow-up questions, ask away. Still have time. You as well. You have time. You can ask your question right now. I'll be here for at least another 10 minutes answering your question. So take advantage, ask your question. So Antoinette, who's dealing with workplace harassment, says, I'm scared that they will let me go. Well, they can't legally do that. And if they do, I'll come down on them pretty hard. They cannot legally do that. You have this shield of protection around you if you complain about workplace harassment. All right. So the one thing I can tell you for sure is that nothing will be solved if you simply don't say anything. So it's really simple. Either you do something to resolve the issue or you let it continue. I can tell you that the laws protect you, so trust the laws, trust the process, and any problems, you call me, all right? employmentlawyer.ca to get all the contact information, phone numbers, email addresses to reach out to me as well. If you have issues, don't wait till the next Facebook session or YouTube session. Call me now, today, tomorrow, whenever you want, or email. employmentlawyer.ca has all that contact information. Next question from Aaliyah again. There's been a lot of unfairness at my workplace as well. She gives me a hard work and the other few people easy work who are hired by an agency. So again, that could also be a constructive dismissal if you're picked on. So it's certainly things that we need to discuss, Aaliyah, and best thing is so I can get particulars from you about your job, about your company, about what they're having you do. We need to have that private chat. So again, employmentlawyer.ca to have that private chat so that we can really get into it. So thank you for that, Aaliyah. Next question from Claudine back on Facebook. My record of employment was submitted late by my employer and caused my EI claim to be denied. It took forever to have it reopened and caused the money to come in January 21, affecting now income tax. How can my employer get away with that? And that's a terrible situation, and unfortunately one that I've seen many times. There is really, our law has not created penalties really for employers to that they don't do what they're supposed to with the record of employment. So there's not much that you can do in that situation. It's ridiculous. I get asked this often, but it's not like I can say, well, here's the punishment that they get. If there was a punishment, that's up to CRA. Not much that you can do in that situation. Now, what I would say to any employee that's not getting the record of employment on time, let me give the company a kick in the pants. Usually when they hear from me, things happen really quickly, okay? So if you or anyone else are ever in a situation where the company is not giving you something that they're required to give you, guess what? They don't ignore me. They can't ignore me. So let me help you if you're ever in that situation. All right. Thank you very much for that, Claudine, as well. Hey, we have 7-8 minutes to go. Ask questions, guys. Please don't be bashful. Okay, let's see. Moving on. Next question from Paul. Can I not review my human resource personnel file to ensure that the contents within it are accurate and correct? This is the information the employer may be relying on and may be not accurate or correct. So they don't have to give it to you. Now, here's the thing. Your employer has to prove things, Paul. So if you're involved in a legal dispute, they have to prove that it's correct. You don't have to disprove it. And they'll have to give you copies of anything that they're relying on as part of the legal process, okay? So I honestly, I would not stress over it. And frankly, anything that happened years ago would be irrelevant, 100% irrelevant to what's happening now. Do not stress over it. I know it seems like it's important. It really isn't. You got to trust me on that. So Antoinette wants my email address. Antoinette, rather than me spell it out for you, here's the best way to get my email address. Go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see there under my bio, my phone number, my email address. Best way to do that, rather than me spelling you my first and last name, it's a mouthful. Just go to employmentlawyer.ca and you'll see all that contact information there as well. All right, so thank you for that. Now, I mentioned before, by the way, last few questions, call or don't call, not yet. Ask the questions, type them in. I'm still here answering your questions. But I mentioned before the tool pocketemploymentlawyer.ca. Pocket, like your pocket, pocketemploymentlawyer.ca. What is it? Well, we're using technology here to be able to advise and assess and analyze your legal situation. So pocketemploymentlawyer.ca can calculate your severance. You answer 3 questions, you find out how much severance you're owed. Easy. Anonymous, free, by the way. No cards, no names, no strings attached. Pocketemploymentlawyer.ca. But it does other things. If you want to find out if the company had just cause to let you go there as well. If you want to find out if you're an employee or an independent contractor, many people are misclassified, and you want to know, am I really an independent contractor? You're probably not. You go to pocketemploymentlawyer.ca. Or maybe you want to find out if your matter is considered harassment or a human rights violation, or maybe you have issues with your long-term disability insurance company. All of that can be done and analyzed at pocketemploymentlawyer.ca. It's like having me and my team with you at all times on your smartphone, on your desktop, whatever you want. So check it out at pocketemploymentlawyer.ca. So from Cameron, HR from a startup company said through email that I would be able to have options to buy stock based on my performance. Is an email enough? Well, no, I'd like there to be something in writing. If there's a promise, that promise has to be clear and in writing. I don't want it to be misunderstood. If it's important, we need to have it in a proper agreement, Cameron, okay? Very important. From Brian, next question. I work as an electrician at a factory. My position is essential, but I'm not sure. Who is classified as an essential right now? Well, let's wait to see what the government announces. That changes all the time. Okay, I can't answer that in the vacuum because in about half hour things are about to change. So we'll have to see. Questions are coming in. That's great. Claudine on Facebook. I remember signing an employment contract, but was not given a copy. I sent email requesting a copy, no answer. So I decided to go on site and was told there is no contract in my file. Okay, well, so in terms of getting that contract, the question is, why do you need it? If you've been terminated, then let's analyze what you're actually owed, and we'll get the copy of the contract when the time comes. I wouldn't worry about that. They won't respond to you, they will respond to me. And if there isn't a contract on file, that's good, that's better. You don't want a contract, okay? Much, much better for you not to have it. So I wouldn't stress out over it. If you're let go, it's our job to help you get the compensation that you are owed. So contact us, employmentlawyer.ca. So let me see here. Next question from In It to Win It. I love it. How long does litigation last for before going to trial if fired without cause because medical leave? It's been a year now in litigation. Well, most cases don't even need to go into litigation. If you have to go to trial, it could take 1.5 years to get to trial, but 1% of cases ever make it to trial, 1%, and even less than that probably. So the vast majority of cases should resolve much sooner before you even see a trial, okay? So let's talk about your matter specifically. You may not be getting the advice you need. Happy to connect with you to assess what you're owed and to assess your situation. Okay, I see. So Claudine, if you can't get a copy of your contract, we can assess your entitlements without it, and we can get a copy of the contract later. If you cannot get a copy of the contract, that's fine. I think you're working with Brock. Just tell Brock, can't get it, tried, and then Brock will deal with it. You don't have to worry about it, okay? If you've tried, it's always good to have it so we can see what it says. If you can't get it, do not worry about it. We can deal with it. Just tell Brock, can't get it, and he'll help you. Okay, wow, this was a busy session. It was a great session, a lot of questions. I enjoyed it. Hopefully you've learned something new today. Hopefully you found out more about your rights. Now, we're going to be shutting this off in a few seconds here, but I'm not going anywhere. My team is not going anywhere. We're here available to help you. Sorry, Claudine says, how long after being laid off can we pursue legal action? Immediately, now, today, right away. All right, so you can do that. Don't wait till next time. I'll be back next week, same time, same place. But don't wait until then. If you have other questions or issues, contact me privately. We can have that private discussion over the phone or through email. Maybe just email me a question, not a problem, and I'll help you. All right? Don't be bashful. There's no bad questions. There's only answers and solutions. So I love doing this session. I love answering questions. I'll continue answering questions off Facebook, off YouTube. So please ask those as well. The website to go to one last time, employmentlawyer.ca. Again, employmentlawyer.ca. Thanks for joining us today. Always a pleasure and a privilege. I'll be back next week. Look forward to connecting. And please, please take care of yourselves. All the best.